All right, so you are Daryl Spencer?
Yes, ma'am.
And Mr. Spencer has 4 cases, 24 DCCR, 1...
Right out the gate, notice how calm the judge is. But don't be fooled. When a defendant walks in with 4 pending cases, that calm is just the deep breath before the storm. And trust me, storms in courtrooms don't use umbrellas.
1863, charged with possession of marijuana. 25 DCCR 1149, charged with evading arrest or detention with the use of a vehicle. 25 DCCR 1150, charged with unlawful possession of a firearm by a felon. And then 24 DCCR 0841, also charged with evading arrest or detention with the use of a vehicle. And the state has filed motions in those 2 newer cases, cause numbers 25 DCCR 1149 and 1150, to raise the bond in those, or increase the bond. It looks like the current bond in each of those cases is $15,000. The bonds on those 2 previous cases, one was $7,500 and one was $25,000. And Ms. Malfino, you may proceed.
Judge, based on the fact that Mr. Spencer was out on bond, bless you, and then committed at least 2 additional felony offenses, we would ask, just based on the totality of the circumstances, the offenses themselves, the court raise all of those bonds.
This is a big moment. Prosecutors rarely ask to raise bond unless they're confident the judge will bite. And the key word here? Out on bond and committed new offenses. Judges treat that like breaking a promise, and court promises are the last thing you want to break.
Place him back in custody. And I will provide discovery to Mr. Kimler on the 2 new cases. He indicates today that he's going to be hired on those, but
I have you on all of them, right?
Yeah, I'm on all of them.
Okay, I'll make sure.
If everyone will give me just a minute, I am going to take judicial notice of the court's files and all of the cases, which include the probable cause affidavit in those 2, well, all of them. Give me just a second to...
Just to be clear, the offense dates on the 2 new offenses are after the other 2 offenses, is that right?
Yeah, so the offense dates on the 2, we've got the possession of marijuana offense date of February 15th of 2024, and the evading arrest or detention from March 2nd of 2024. And then we've got 2 new cases, one from June 14th of 2025, the evading arrest or detention with the use of a vehicle, and then June 15th, the unlawful possession of a firearm by a felon of this year. So give me just a second to review all of this, and then I'll let you.
While the judge flips through the files, listen closely. These dates matter because the order of offenses tells a story. And in this case, the story is basically released, reoffended, released, reoffended again. That pattern is courtroom kryptonite.
Sorry, I should have had these done already.
Maybe it's...
I've got one more I'm coming, I think. That's what I'm see. 08. All right, so let's see. On the two older cases, it looks like bond was made May 24th of 2024, so he was definitely out on bond on those when the two new. I should have one more.
Additionally, Judge, he has been before this court before in 2017, as well as next door and in front.
So we've got, here's the,
We're gonna just go with the Class A amount. When this piles up heavy. Yeah, it's gonna drag it. So this might be less than 750. Less than 750. Yeah, that should get us to what, Class A or B?
Yes, that's enough.
Let's do A, that's what it is.
all right, so the unlawful possession of a firearm by felon and that evading, same offense, or date, pretty much same. And then okay, I should have another one. I should have one. Is there not anything else I printed?
Two of them are the same.
I know. I should have three. These two are the same, but I should have this one and another one. I thought
That's three printed.
okay, hold on.
Yeah.
All right.
I think I filed them in both cases.
You did. I'm just trying to find the
The same
PCs
PC.
from the, I'm trying to look at the underlying PCs as well. So give me just a second to pull up the, which one is, what am I trying to
Well, it'd be the
find?
same, probably the same PC for each case.
Evading.
You can feel the judge getting frustrated. Anytime the paperwork starts multiplying like gremlins, it signals one thing. The defendant's history is longer than the judge expected, and longer history equals shorter patience.
0841. I didn't just print this one?
And two of them look just the same, but there's still stuff in it. And it's
Okay, maybe that's it.
this stuff's just there.
Why did it do two? What's happening? Okay.
I'll sign it out.
So you said he's previously been in other courts. What other, do you have convictions?
I do, Judge, I do have a conviction in this court from May of 2017, 9 months in state jail for engaging in organized criminal activity. Also, it appears that in 2017, he was also in drug court for third-degree possession. It looks like he received probation on that case. There was a knock on that, so I don't want to misrepresent that. He did get 3 years TDC on that, Judge, on revocation, and then in CDC back in 2023, he was given a lesser included Class A deadly conduct where he served 1 year in jail.
Mr. Kimler?
Well, Your Honor, I'm not prepared to litigate the merits of the two new cases without compromising defense. I suppose the court will have to stand on the PC.
And there it is, the turning point. Once the judge references criminal history plus new felonies while on bond, that's basically the legal equivalent of a knockout punch. At this stage, the bond increase isn't a question anymore. It's just the judge deciding how high she wants to raise it.
I know that he's employed, is that correct? He's working longshoreman and is endeavoring to maintain a law-abiding lifestyle. I believe he could pass a drug test in lieu of an increased bond if the court is inclined to take some sort of remedial measures. Regarding Mr. Spencer's conduct while on bond for the previous two cases, I would suggest a GPS device in lieu of an increased bond.
I don't see how a GPS is going to help when you're out on bond. You've got 2 felony convictions, a state jail and a TDC conviction. You're out on bond for a felony possession of marijuana and an evading arrest, and there's an additional arrest for an evading and an unlawful possession of a firearm by a felon. I'm going to, based on the criminal history, based on the nature of the underlying offenses, and all of the factors in 17.15, I am going to grant the state's motion to increase bond in cause numbers 251149 and 251150. I'm going to raise the bond in each of those cases to $100,000. Condition of those bonds, if made, are that Mr. Spencer not be allowed to drive a vehicle, period, on bond, and that he I'm not worried about that necessarily. Obviously can't have a firearm, but I'm no driving whatsoever. All right, you can go back with the bailiff, and I'll reset the case.
4 cases. 1 defendant. Calm fills the courtroom, but it's the kind that comes before impact. As the charges stack higher, one question hangs in the air: how much patience does the judge really have? Released on bond, Daryl Spencer didn't slow down, he doubled back into trouble. New felonies surfaced, dates exposing a cycle the court can't ignore. Now, with his past uncovered, the only mystery left is how hard the hammer will fall. Daryl Spencer stands before the court, calm on the surface, yet surrounded by 4 criminal cases that quietly scream escalation. The judge, measured and patient, listens as prosecutors outline a troubling timeline: release, reoffend, release, reoffend again. Each charge piles weight onto the room: marijuana possession, evading arrest, then the most dangerous detail: unlawful possession of a firearm by a felon. As the judge reviews files, silence builds. Dates tell their own story, one the defense cannot rewrite. Paperwork multiplies, and with it, frustration. A prior conviction surfaces, then another. Organized criminal activity. Drug court. State jail. Probation violated, second chances spent. The defense pivots toward mercy, offering employment, clean tests, even GPS monitoring. The judge is unmoved. History, not promises, rules this moment. When she speaks, her logic is surgical: repeated felonies while on bond demand consequence. The ruling lands hard. Bonds soar to $100,000 each. Driving privileges erased. Freedom narrowed to conditions and custody. Daryl Spencer is led away, a man outpaced by his own pattern. This courtroom moment is not just about bond, it is a warning. Justice remembers, patience fades, and choices echo longer than excuses, leaving one haunting question: how many chances does freedom truly give before it closes the door forever? The answer lingers in the air: every observer that the courtroom